Good morning. Please be seated. We are here for oral argument in cause number CV18-0010, Gallardo et al. Versus West Sand et al. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs, have discussed this case in conference. You can assume that we are familiar with your arguments. All right, at this point, you may proceed, counsel.
May it please the court, my name is David Abney. I'm representing the appellants. I had a surgery at the end of September, and I'm still on some very interesting pain medications. So if I'm a bit loopier than usual, which is probably hard to tell, please ascribe that to the medication. Our central premise is there's a jury issue here, whether there's been reasonable diligence or not. As judges and as lawyers, you know it's always possible to be more diligent in whatever you do. Always possible to do another draft of something, always possible to push the boundaries of your discovery a little bit further than you pushed. But in this case, Mr. Ortega decided that his best strategy would be to maintain contact with the attorney representing Mr. Mendoza in the criminal matter, to check periodically to see if Mr. Mendoza would be willing to talk freely about what happened, and possibly reveal the existence of dram shop in the case. At that point, Mr. Ortega had filed a lawsuit within the 2-year statute of limitations, not knowing if there was a dram shop liability or not, but he wanted to preserve the rights of his clients just in case there was dram shop liability. I'm sure that if he hadn't done that, my colleagues across the aisle would be saying that he's violated his duty by not filing a lawsuit within the statute of limitations period. So it's sort of a, it's a difficult situation. And I think it was very creative of Mr. Ortega to file that lawsuit. I don't think I would have thought to do it, and he did. And then he gained extensions from the court, which were granted, to try to continue the process of working with the lawyer for Mr. Mendoza to find out if Mr. Mendoza would say some more.
What would you have done if Mr. Mendoza had died in the same car accident? Aren't there presumably some ways to go about figuring out if there's a possible dram shop?
If he had died, I think you could do what Mr. Ortega did once he got information from Mr. Mendoza that, I was at a bar, and I think he identified.
But I'm saying Mr. Mendoza died in the car accident, so you're not getting any information from Mr. Mendoza, but you still have a potential dram shop.
Yeah, well, you could try a shotgun approach. You could try, say, well, maybe there's a credit card receipt somewhere, or maybe there's a bank debit record someplace. You could try going and serving subpoenas, file a lawsuit, and serving a smorgasbord of subpoenas on banks and financial institutions and credit card companies, and maybe that would work. Maybe not.
Or perhaps you could just sue the estate, in Judge Catani's hypothetical, Mr. Mendoza's estate, and then do the interrogatories, et cetera, to find out other information.
Well, maybe. In this case, there was a 1530 minimum policy for Mr. Mendoza, and the Gallardos decided they wanted to take the minimum policy, which was naturally enough tendered. At that point, you're done as far as suing Mr. Mendoza. You can't take a settlement and then sue the person that you settled with. So, I mean,
but that is a strategic decision that is made by your clients. The bottom line is there are many ways they could have obtained that information even without help from Mr. Mendoza.
Absolutely. I'm not going to try to sugarcoat this. There were ways to be more diligent in this case. There are always ways to be more diligent. But the strategy that Mr. Ortega undertook actually did work. He did get more information from Mr. Mendoza, and that opened the door to get even more information, and then we wound up with the 2 dram shop defendants. We still don't know exactly what they did or did not do, other than it appears that they served Mr. Mendoza with alcoholic beverages, and since he was under 21, that itself is a violation of the standard of care statute and the standard of care. And time would reveal other things. Perhaps they served him to the point where he became obviously intoxicated and then did nothing about it. Or perhaps when they served him with alcohol, he was obviously intoxicated right at the start.
But
So-
at what point is it too late, given that we do have a statute of limitations? Let's say Mr. Mendoza had been charged, the state had sought the death penalty, and the trial's going to it'll take 4 years to get to trial. I mean, at some point, doesn't that kind of go against the underlying purpose of a statute of limitations when the claims become a little bit stale, the memories are lost, and if you're going to wait, how long, in your view, would be too long to wait to put the defendants on notice that there's a possible dram shop?
I hate to say this, but I don't know how to answer the question. There would come a point, but I think the decision maker of where that point is, unless it's like 2 decades or something just utterly outrageous, but the decision maker for where that point is the trier of fact. That's what the cases have said over and over, that the reasonable diligence issue is one for the trier of fact. Now, you may say, well, if I had been in charge, I would have done X, Y, Z, but what Mr. Ortega did work in the end. And he had extensions. He filed the lawsuit and he gained extensions from the court. And within the period of the extensions, he did manage to discover the dram shops that seemed to be involved in this and filed the amended complaint. And here we are with the lawsuit in effect against the 2 dram shops.
Mr. Ebony, so your position is it's always a question for the trier of fact, and the Superior Court has no role in determining whether or not due diligence was exercised in a particular case?
No and yes. There's got to be a point, and there are some cases where it's just such a huge amount of time that I think the court...
Well, there was a lot of time in this case.
Pardon me?
There was a lot of time in this case.
There was. But it's still within the period. He still filed within the statute of limitations. He gained extensions within the period, gained extensions from the Superior Court, and within that period of extended period, then there was revelation, discovery of the dram shops, and amended complaints dealing with the dram shops. So this isn't one of those cases where a decade has gone by.
But what did he do within the period of the statute of limitations? I'm not seeing any kind of... What were the diligent efforts during the initial period that would have been the statute of limitations period? Just waiting doesn't seem like diligence.
Well, it is a way of doing things, but he contacted periodically the criminal lawyer representing Mendoza. That's why when the plea bargain was finally done, and Mendoza was protected at that point, he was going to have his plea bargain, he was going to go forward. Mr. Mendoza decided to be cooperative, and his lawyer then informed Mr. Ortega that finally his client was willing to talk with him. They had an interview on June 21st, 2016, and the light was shed on what happened. So that was his strategy, was to check periodically with the criminal lawyer and to find out at what point Mr. Mendoza would be more forthcoming. And
was
he
there
was.
A formal invocation of his Fifth Amendment rights? Did he invoke during the criminal proceedings?
Oh yes, the Fifth Amendment, absolutely.
What was the point where he invoked?
Right from the beginning.
Well, he talked initially
Well,
and acknowledged that he'd been drinking.
He gave some information, naturally enough. A lot of folks do when the police are right there and something bad has happened. They spill some beans, and then later on he clammed up. And he wouldn't say what was the truth. Apparently, the truth is that he was served with alcohol. Now, the actual scope of the truth we still don't know. Maybe he was at these bars buying drinks for other people. We just don't know the reality of what exactly happened, and we can't know at this stage because discovery was stopped when the motions to dismiss came through the door. But when I was in the Navy, they used to say to me, Abney, if it's stupid and it works, it ain't stupid. And what he did, it may not be the most diligent way of doing this, but it worked. And he found out the information within the extended period of time granted by the trial court, and then went forward.
Far outside the statute of limitations, so we go back to how long is too long?
Well, that's something for the jury to decide. And this can be done with a simple interrogatory.
When we look at times that we use the discovery rule to extend the statute or toll the statute of limitations, we look at fraudulent concealment, we look at other things. Do you think this is akin to that because he invoked his Fifth Amendment right? And when we talk about invocation, he exercised his right to remain silent. He did not invoke on the stand, correct?
Correct. And he wouldn't. When the beans were finally spilled fully toward the end, or semi-fully at least identified one bar, At that point, he had everything to gain by being cooperative with the lawyer representing the victim's family, because they then can put in a good word for him at the sentencing hearing, or at least not say the full range of what they would want to say about the person that killed their son. So it was a huge motive on his part. When you got to that point in the proceedings, he's protected, and now he can maybe things will go smoothly, more smoothly than he could hope, if he can just get the family on a little bit on his side, or a little bit less not on his side.
So let's get back to fraudulent concealment.
Oh, thank you. No, I don't think it's really like fraudulent concealment, but it is a major roadblock. In the sense that fraudulent concealment is a big roadblock to trying to find out the truth, but clamming up is also a big roadblock. So they're related that way. But
When we look at motions to dismiss and responses to motions to dismiss, fraudulent concealment is one way to get around the statute of limitations problem. What do you believe your best argument is? That he just wouldn't talk and do nothing?
the best argument is that is the strategy that Mr. Ortega devised, and it was, I think that this man is going to be forthcoming, more forthcoming, possibly, than he has been. When he finally gets to the point where his lawyer lets me talk with him because he gets a plea bargain, then there's no reason he can't just be completely candid about what happened. Remember, Mr. Ortega still doesn't know that there's any dram shop involved at all. All he has from Mr. Mendoza is, I was drinking with a friend. And that's not going to do anybody a whole lot of good as far as a tort recovery.
So how many months went by after the disclosure by Mr. Mendoza and the adding of the defendants, the Second Amendment complaint? How much time went by?
Well, I think it was a couple months or less. It wasn't very long. It was within the period of time for the extension, so it was within the range of what had been allowed by the trial court.
Is the rule you're looking for in this case the simple fact that until the known defendant is willing to talk, that the statute's told? Because that sounds like what you're advocating.
No, not at all. That happens to be what's sort of the situation in this case. But no, the rule is the one I advocated and listed all the cases that say the same rule over and over. It's page 8 of one reply brief and page 11 of another. I just listed all of them. I discussed them, mentioned earlier. But the general rule is that when there's an issue of reasonable diligence, it's a question of fact for the jury. And that's the rule that I'm advocating for the court today. Nothing revolutionary.
When I asked you before, and I asked if the Superior Court had no role in making that determination, you said they have some role.
Yes, there will be some cases, I'm sure there will be, where an event happens in 1970 and you don't do anything until 1995. There will be some periods where it's just outrageously.
Okay, so we can agree that the 2 decades is too long. What about 1 decade?
I don't know. It might be.
How about 5 years?
I don't know.
Well, but that's my
If
point.
you get to the point of 5 years, I'd be thinking this is jury. The jury's got to decide this. There is a tremendous.
Could we not say though, why not within the period of the statute of limitations? Couldn't we expect some effort within that period, and with some effort being something other than waiting, because that's not really. Why couldn't we expect at least attempting to do discovery, whether it's by filing a lawsuit and just doing the minimal discovery, getting credit card records? Wouldn't that be more in harmony with a statute of limitations, that we would require some diligence during that period? Otherwise, if the only activity happens after the statute has run, it's hard to say that's diligence.
Well, as far as the initial level of he did file a complaint within the statute of limitations period, even though he didn't know if there were these dram shop things around. Did file the complaint, and then consciously adopted a strategy. I'm going to contact the defense lawyer. That's the strategy that he's using, and then it works at the end within the period of time extended by the trial court after filing the initial complaint.
Did Mr. Ortega ever ask the lawyer for Mr. Mendoza for the names and the information of where he had been drinking? We knew he was drinking because he told the police officers at the scene he had been drinking.
Yes, he did, although the fundamental inquiry that he was after was, may I speak with your client about this and get the true skinny on what's up. But he did talk with the lawyer about revealing information the lawyer declined and said, I'm not going to basically, I'm not going to tell you anything, and he's not going to tell you anything. Let's talk closer to plea
And where
bargaining.
exactly is this in the record?
That is set out in the responses to the motions to dismiss.
And it's just that blanket statement?
Not in great detail, but it is in the motion to the
And
responses
that's
to
the
the motions.
extent of, that's the extent of what we have.
Yes.
Is in the response. He said, the response pleading said, I contacted the lawyer for
Yeah.
Mr. Mendoza and he wouldn't cooperate.
Yes, and of course, an avowal by a lawyer ought to carry a considerable weight with any
I'm not saying it
court.
isn't. I'm just curious if a letter had been sent or something, and
No, these-
attachments or something
These
more
were-
concrete about what was specifically communicated.
These were by conversations, Mr. Ortega with the lawyer for Mr. Mendoza. If I may preserve my remaining time. Thank you.
Good morning, and may it please the court. I'm John Barnes, here for West Sand LLC, and with me at counsel's table is Kenneth Peace, with whom I'm splitting my time this morning. We're here on appeal from a motion to dismiss, and the operative complaint has no allegations that support the plaintiff's accrual arguments. It does not allege that the Gallardos took any affirmative steps to discover their claims against West Sand, nor does it allege that those claims were difficult to detect.
Does it necessarily have to be in the complaint? Can't it be in response to a motion to dismiss? Let's say there were legitimate reasons and there was a lot of activity, a lot of discovery that was done, attempted. Would we limit ourselves to what's in the complaint, or could we consider what was proffered in response to a motion to dismiss?
Well, Judge, I don't have to tell you that in reviewing a motion to dismiss, the court limits its review to the allegations. Now, if plaintiff's counsel had attached something in the record showing that they're documenting the supposed diligence, then the trial court might have been faced with the question of whether to convert the motion into a summary judgment motion, viewing something beyond the pleadings. But that's not the posture in which this case comes on appeal.
You'd have to attach an affidavit, is what you're suggesting, or something.
Right,
along
exactly,
those lines.
Judge. And so without anything in the record like that, or any allegations in the operative complaint, there's nothing to create a factual dispute for the jury to decide. On the face of the complaint itself, the claims are conclusively time barred.
Where you are acknowledging, even if it's not in the complaint, but if there's an affidavit that's submitted after the complaint, maybe in response to the motion to dismiss, the affidavit is something the court could consider?
What I'm saying is, hypothetically, in that situation, the trial court would have to decide whether to convert the motion to dismiss into a motion for summary judgment by looking beyond the pleadings. But again, there's nothing in the record here along those lines. So I don't think that that's a situation that this court is presented with.
So, counsel, in their response, they included, we filed the motion to extend, we did this, we did that, we did the other thing. If that had been contained in the second amended complaint, do you think that complaint would then pass muster regarding reasonable diligence?
No, I don't, Judge, and here's why. The only thing that the motion papers asserted was that the at-fault driver invoked his Fifth Amendment rights and refused to volunteer any information. And it didn't assert that the Gallardos did anything to investigate their claims. Now, they're not state actors, so they weren't precluded from at least requesting to interview the driver themselves, nor were they foreclosed from pursuing the other potential avenues of discovery that Judge Catani outlined earlier, such as bank records or phone records from the night of the accident. So to answer your, in short, Judge, no. I don't think that would satisfy the diligence requirement, because at the end of the day, they didn't do anything. They did nothing. And with that...
Where do you draw the distinction between what is a jury question or a question for the trier of fact versus when the trial court can intervene and say there's been nothing done here, as it relates to due diligence?
Well, I think the record has to show some... it's a know or should know standard. And here the Gallardos clearly had notice of potential dram shop claims. That's what they've asserted from the inception.
Well, yeah, they filed a complaint.
Yeah, and so they did nothing to investigate the basis for the basis for those dram shop claims. And so, to answer your question, Judge, I think that
According to Mr. Abney, they called up the lawyer for Mr. Mendoza and said, "Can we talk to your client?" And he said no.
well,
So why isn't at that point it become a jury question?
that's not in the record, Judge. I mean, again, we're here.
Not in the response pleading? The response to the motion to dismiss?
Well, assertions of counsel in the response brief, again, it's a motion to dismiss, and the trial court's looking at the pleadings, the allegations in the complaint.
Okay, so are you basing your argument on that the lawyer, Mr. Ortega, didn't include an affidavit to his motion to dismiss, saying this is what I did?
I'm saying, well, I mean, that's part of it, Judge. Yeah, there's nothing in the record to support those assertions. They're
If you
just
had included such an affidavit, would you agree that that would then be an issue for the trier of fact?
I wouldn't agree, but I would agree that we would have a different procedural posture because the trial court would have been faced with a different question. The defendants, in briefing the motion to dismiss, would have been faced with a different situation in presenting evidence of their own, and the case would have evolved potentially entirely differently. And because that's not the record before this court, I don't think that that's material to the court's decision today. And unless there are any other questions for me, I'll give Mr. Peace a chance. Thank you.
Good morning. May it please the court, my name is Ken Peace. I represent McFadden's in this matter. In response to, I believe, Judge McMurdy's question, McMurdy, sorry.
All right. Been called worse.
I did look at the plaintiff's response brief to the original motion to dismiss, and there is no discussion of Mr. Ortega contacting plaintiff's counsel. Now, that being said, I think this Fifth Amendment, I think the invocation of the Fifth Amendment argument that Mr. Ortega has been making is actually a red herring. I believe that the case law is fairly clear that Mr. Mendoza waived his Fifth Amendment rights when he submitted to a field sobriety test, submitted to a breathalyzer, submitted to a blood draw, told the officers that he had been drinking, and then finally, on June 21st, prior to sentencing, prior to changing his plea, he agreed to meet with Mr. Ortega and discuss which bar he had been drinking at.
You can't invoke after having made some statements?
I believe the case law, and I have, in fact, it's in Mr. Abney's brief. The case law says, I'm sorry, excuse me, no, it's in Sandbar's brief. The case law says once you open the door on an issue subject to the Fifth Amendment, that you've opened the door. So, and that is I believe that's the United States versus Hearst matter, where the waiver of a privilege against self-incrimination on a certain subject matter constitutes a waiver as to matters reasonably related to that subject matter. But notwithstanding the waiver argument, I also believe...
Well, do we know in this record when he officially, or if he officially invoked?
We do not.
Okay, so there's no, is there a police report or something that would say, he said, I'm invoking my rights, don't talk to me?
I have not memorized the police report, but I do not believe that that's in there. I do not believe at some point while he's being questioned, he says, I need to talk to a lawyer, I'm invoking my Fifth Amendment rights.
So it is the only, because when I was reading the response, the only thing I saw was that Mr. Ortega said, I contacted his lawyer, and his lawyer said, we don't want to talk to you.
I believe that is the status of the record, yes.
Is that an indication of somebody's Fifth Amendment right?
I don't believe so. I don't believe, I don't believe so, but because, the other issue is, notwithstanding the waiver issue, I don't believe where Mr. Mendoza was drinking is protected by the Fifth Amendment. We know that he was driving. We know that his blood alcohol was a .167. We know that Mr. Gallardo.
Fifth Amendment does protect him from having to say anything more than what he has already said, presumably.
But where he was drinking is not an element of any criminal charge that he was facing.
But the state could not pursue that information from him if he invokes his Fifth Amendment rights. Would you agree with that? I think it's a different question. Can someone filing a lawsuit pursue that information? But if a defendant invokes at any point during questioning, that would prevent the state from asking further questions about where were you drinking, what were you doing, presumably.
I don't believe so, I don't believe that's the case based on the Hearst case. I think once he has volunteered that he was drinking, once he's taken consented to a field sobriety test and all that stuff, I think where he was drinking is really is a red herring.
But he has to keep answering questions just because he's volunteered that?
It's not an element to any criminal charge that he was facing where he was drinking. Now, and again, I mean that is what I believe the Hearst decision, the interpretation of the Hearst decision would be. Certainly, if they were asking him questions, how much you drank, were you speeding, or all that stuff, were you reckless, all that stuff, I think that would be subject to the Fifth Amendment. But where he was drinking is irrelevant to any charge that he was facing. So,
Well, see, I tell you, I'm having a hard time with that argument, just for the simple fact that if the state became aware of it, they could go and look at his credit card records and then determine that he purchased, more than 2 beers. So why isn't that testimonial?
well, first of all, I don't believe financial records. I don't believe financial records are outside the realm of what the state can actually obtain. I think they can serve a subpoena on his bank.
Well, if they knew it.
Right. Well, and that was the position taken in the motion to dismiss. That relevant to Judge Catani's argument that why couldn't you, if Mr. Mendoza had passed away in this accident, why couldn't you serve a subpoena on the 5 or 10 largest banks? And in this situation, he banked at Chase, the largest bank in Arizona. So that would clearly have been a subpoena that should have been served. And we know in this situation, I mean, Mr. Gallardo's passed away. His damages are a snapshot at that moment. So there's no reason to wait 2 years to file a complaint and then serve all Doe defendants. And again, you heard Mr. Abney say, we didn't know if there was dram shop liability. We didn't know if he was served even. We didn't know any of this stuff. I don't know how that doesn't violate Rule 11. He's avowing in a pleading, in a complaint, that this John Doe defendant was liable for statutory dram shop liability, common law dram shop liability, and negligent hiring, training, and supervision. I don't know how that's not a violation when even here Mr. Abney is saying we don't know if there was any dram shop activity. So, and again, the Rule 11 requires reasonable diligence also. So the fact is, there is nothing contained in the second amended complaint that even addresses the delay, that even at all. The only thing in the second amended complaint, and I believe this is why Judge Lemaire said that we're not going to allow plaintiffs to amend their complaint, the only thing in the second amended complaint actually says at paragraph 8, the Glendale Police Department responded and began to investigate the collision. While DUI officers Johnson and Henderson conducted the standard field sobriety tests and PBT breathalyzer test on Mendoza, Mendoza failed the field test and his breath sample had a BAC level of 0.167. He was arrested and a warrant was secured to collect 3 blood samples draws for the purpose of retrograde. One of the analysis of a specimen blood was 0.178. And paragraph 9 says, after his arrest, Mendoza admitted that he had been drinking just before the accident. So what's contained in the complaint actually defeats this delayed accrual argument. It says, I mean, at the time of the accident, he submitted to a field sobriety test, a breathalyzer.
He also indicate at some point that he was drinking at a friend's house?
Yes.
Isn't that their point, though, that that's all we knew at that time?
Right.
And it took until we actually interviewed him, we found out that he had alcohol somewhere other than at a friend's house.
That was almost a year and a half after the initial complaint was filed. The interview was June 21 of 2017, and
let's say that happens within the statute of limitations period. The fact that it happens after the complaint's filed wouldn't prevent them from pursuing that, would it?
I don't think I understand your question. I'm sorry.
Well, I'm just saying the fact that it's not in the original complaint, if they had, let's say they had filed the complaint 2 months after the accident, it's not in the complaint, but they find out something much later, let's say the day before the statute of limitations is going to run, they find out that he acknowledges that he was drinking somewhere else. The fact that it's not in the complaint doesn't preclude them from going forward with a dram shop case, does it?
The fact that it's not in the complaint would not be a factor if the complaint had been filed timely. The issue here is there's nothing in the complaint that would toll the statute to 3.5 years. So if he had filed a timely complaint,
and sorry to interrupt, but does it have to be in the complaint? Can he submit an affidavit after the complaint's filed? Here's an affidavit that says this is what I just learned. So we're not just focused on the complaint, we're focused on whatever is before the court. Would you agree with that?
no. I believe the case law says that when considering a motion to dismiss, you look at the 4 corners of the complaint, and I agree with what Mr. Barnes said, that if Mr. Ortega wants to attach an affidavit, then it's up to the trial court to determine whether they're going to treat it as a motion for summary judgment.
So let's assume we are treating this as a motion for summary judgment. Does that change the analysis if we consider, let's say there's an affidavit attached to the motion to dismiss that says, I was in constant contact with his attorney as soon as he decided he was going to take the plea. We interviewed him. We found out who the defendants were. So a motion for summary judgment. Take it from there. Does the response change the statute of limitations arguments?
Well, I think yeah. I think that that if the trial court decided to consider it as a motion for summary judgment, then the record here is different, of course, because there was no activity. But if there was some activity alleged in the motion for summary judgment, then I think
what we've been discussing today. The activity was staying in constant contact with the defense attorney to find out when he would take a plea agreement, and then engaging in a interview to determine who the proper defendants were.
I think the trial court has the ability to determine what reasonable diligence is. And I think that's a case that actually Mr. Abney raised in his, bear with me a second. Excuse me, that's the Coulter versus Grant Thornton case. And I mean, I think we all agree today that the appellate court's review is de novo, but this Grant Thornton case says that that the appellate review for the court is abuse of discretion when the Court of Appeals is reviewing the trial court's determination regarding an exercise of reasonable diligence. So I believe that the trial court can determine reasonable diligence given the lack of diligence in this situation. And I think my time is up.
Time is up. Anything further? Thank you, counsel.
Thank you.
Mr. Abney.
Perhaps briefly, I don't think that the trial judge would be limited to the complaint. When you file a complaint, the first time around I could see putting some information in about difficulties in finding out information, but when you go to the amended complaint, the next amended complaint, why would you include that stuff? It's not something that the jury would really necessarily need to see and would just sort of clog up the complaint.
But let's assume this is an affidavit that's attached and you're there. Is there still, is there a hurdle that you have to get over before it becomes a jury question? Can the court just say there's no diligence, waiting is not diligence? Can the court make that determination? Is everything necessarily a jury issue?
Not everything, but in this case, the things that matter. I mean, in a different case, as I've said, you could go so long and it's just beyond belief. I think it's sort of like the summary judgment standard, or that's the standard that's often applied, that if reasonable jurors could not disagree on this point, then I'm going to go ahead and rule on it. And I think that would apply in many cases, but not in this one. And this one, I think I submit to the court that the general rule would apply, that matters of reasonable diligence are for the jury to decide.
When we talk about a motion to dismiss, we judge it on the four corners of the complaint. So we have a statute of limitations. We are not within that statute of limitations prior to serving the defendants or identifying the defendants. We're a year and a half out. So how would the court determine on a motion to dismiss? I mean, this wasn't the first complaint. This is the second amended complaint. How's the court supposed to know you were being diligent? If you don't put anything in there, all the court sees is the statute of limitations and how much time has passed.
Well, converting this to a motion for summary judgment would be one way to go. It would be a lot clearer, but the trial...
Attach anything. I mean,
right.
There's no affidavit. There's nothing in the record that would create that issue.
Well, in the record, it's in the motions to extend, for sure, and I believe it's also in the responses to the motions to dismiss, explaining the factual situation of what Mr. Ortega was up to.
But we're looking at a motion under Rule 12. We are confined as the court to the four corners of the document. Why wouldn't you put that in there?
Because this is such an important decision, I believe that the trial court can and should look beyond that in this particular case and say, well, what is there in the record on this?
Is there somewhere a case that says they're required to?
No, I don't think there is one that says required to, but under Rule 1, I don't know how you could not, especially when the parties themselves are discussing the situation and saying, well, Mr. Ortega saying, this is the reason why, and the other side saying, well, who cares? You've got these facts on one side, you've got your facts on the other, and I believe that there are situations where the trial court really needs to take a look at the entire record, and this would be one of them. If you're trapped by that looking at the complaint rule, there's some big difficulties, because once you're beyond the first complaint, why would you put stuff in the second complaint about stuff that doesn't matter because you now figured out who you're going to sue? And if the first complaint is, as they say, functus officio, it doesn't matter at all, it's gone, then all of this information just vanishes into the ether, and a complaint is dismissed that should not have been dismissed without giving the jury a chance to think about, well,
if it's not a complaint, how are we giving the jury a chance?
Pardon me?
If it's not in the complaint, how are we giving the jury a chance? I mean, you keep saying this is for the trier of fact, but where is it we're giving it to them if it's not in the complaint?
Well, they will get the chance at the close of the case when there's a special interrogatory to them saying, was this reasonable diligence or not? Check yes or no. And if you check no, well, go home. You're done.
So what's the evidence they're going to be looking at? If there haven't been any affidavits, nothing's been attached to the complaint, nothing's been amended. We're just saying some pleadings where there's some avowal of counsel. That's the evidence that they're.
No. At trial, there's going to be evidence on this. There's going to be Mr. Ortega's evidence and whatever else Mr. Ortega can muster to support the fact that he exercised reasonable diligence, whether it might be deposing the lawyer for Mr. Mendoza.
There isn't, if you're acknowledging that there's no evidence, isn't that the point of, at this point, isn't that the point of a motion to dismiss? We look and there's no evidence before us, and that's why that's a basis to dismiss.
Well, what the trial court has in front of it is the record of the case. And from the record of the case, the trial court can say, well, there is a problem here. I see Mr. Ortega's adopted this strategy, which, by the way, worked within the period of time I gave for an extension.
But it didn't work in terms of disclosing something before the statute of limitations had run.
No, but he did file within the statute of limitations. And then within the extended period beyond that, he did manage to get the amended complaints out. Which listed the dram shop people as defendants. So, yeah, in that sense,
So if a trial court just keeps granting an extension and it ends up being 6 years after the running of after the statute of limitations has run, we're saying the statute of limitations, 2-year statute of limitations doesn't really mean anything as long as somebody has filed a complaint and a court has granted an extension.
It means a lot that he filed within the period of the statute of limitations. There was a complaint filed within the 2-year statute of limitations. And as far as extensions, well, if the trial court is being amenable to that, who are we to say, looking at this from a distance, that wasn't the right thing to do? Extensions were the right thing to do. And actually, everything was done within the period of the extension. And we got these people named as defendants. I mean, oh my gosh, I'm out of time. That's a positive thing. I apologize to the court.
That's okay, Mr. Abney. All right. We thank you both for your arguments. This matter will be taken under advisement, and we will prepare a written order in due course.